Thank you, Mr. Suman, for your inspired thoughts. And may I now request Ms. Leidylin to kindly address the audience and share her thoughts.
Dear INBA members, government officials, councils, judges, lawyers, students, arbitration practitioners, businessmen, dear colleagues, dear participants. Please allow me to thank the Indian National Bar Association, INBA, Mr. Kaviraj Singh and Mr. Axel Heck for the invitation to participate in this magnificent event, for allowing me, just a young lawyer from the Dominican Republic, to share this podium with these luminaries whose contribution to the development of the rule of law precedes them. It has been quite a journey taking me to India, but it certainly is worth it. The invitation is not only special, as it allows me to address an important topic on international arbitration, to which I am devoted and committed, but also for the opportunity to join all the colleagues and being in India, whose culture is in many ways part of my life. I address you today facing an evolving and changing world. The international economic order, as we know it, is certainly changed, and with it comes the changes in the different dynamics. International arbitration, as the most used method for resolving commercial disputes, is not isolated from this. Within international arbitration, the specific phenomenon on investor-state mechanism or investment arbitration is certainly on an epic momentum. It has always amazed me, the possibility that a single person is enabled by virtue of an international investment agreement, law, or contract to present a claim directly against a government, a sovereign, without the need to assist to local courts before to present its claim. A government assists to arbitration and is therefore subject to an award that may impose on them and a decision on how it should apply its own laws, what to do, what is not supposed to be done in order to fulfill its investment commitments. There is, for me, the state at its most vulnerable condition. The system allows an investor to present a claim against the host state of its investment when he considers he has been discriminated, expropriated without compensation, or in any way affected its properties or investment. History and relationship between international investment agreements and governments has been extremely important and gone through a significant evolution. Since a first naive moment in which most of the international investment agreements were signed, to its evolution once we learned the procedural, economic, legal, and administrative implications of protections and standards included in the treaties, which are examined and scrutinized through investment arbitration. If we add to that the very vague, broad, and open content of all dated treaties and the decisions emerged from different tribunals, and in cases where there was no investment or not a significant one with impacts on the economy, then we are closer to the inherent imbalance of the system. At this point, it's mandatory for me to say that I'm not simply against the mechanism. It's part of my day-to-day job and a passion for me. But certainly, for people representing government in investment arbitration, we do face mixed feelings, dealing with an extraordinary system that approaches directly an individual to an international jurisdiction, but on the same time, we face its implications, the difficult situations a government is exposed sometimes, and how many times there is an abuse of the system. Therefore, there was no surprise when a couple of years ago, international organizations such as the United Nations Conference on Trade and Development, UNCTAD, proposed the phase one of the reform of the investment regime, including the preparation of VAT models for the countries with a more precise, coherent content for future international investment agreements, and also including sustainable development content, considering, among other things, jurisprudence from investment tribunals in order to achieve a more efficient, clear content of the agreements. Inconsistency on investment treaty provisions is one of the main critics to the regime, and one of the reasons for the investment tribunals to interpret an inconsistent way treaty provisions. It is said that investment tribunals approach differently diverse investment treaties, but what about tribunals interpreting differently the same provision and the same specific agreement? How does a state knows when it is fulfilling its commitments? Let's leave investors' certainty for a while and consider the predictability for the state to know when it's violating its investment responsibilities. And the complexity and diversity of investment regime do not contribute to the situation. There are certainly incoherent agreements between themselves, but also vague and ambiguous individual agreements. Incoherence is possible not only for two agreements from a same country having different provisions, but also a clause in a specific agreement being interpreted in the most different ways. Both joint interpretations and amendment options offer important possibilities to improve and strengthen treaties' content, but also to reduce the possibility for tribunals to inconsistent and unfair interpretations. In the case of joint interpretations, when the treaty provides its binding for tribunals, it's an important tool before a more complex and time-consuming procedures, such as amendment per se. We can even consider its effect as to avoid state-to-state arbitration for interpreting provisions under BITs, arbitration that is included in the Dominican Republic agreements. Current proposals and debates for initiatives that were inconceivable years ago as proposals for an appeal mechanism as included in the United States Central America Dominican Republic Free Trade Agreement, known as CAFTA-DR, also aim for coherence on investment treaty interpretation and arbitral jurisprudence. Nevertheless, even for initiatives as the Permanent Investment Court, we could ask how will it achieve its objectives with diverse contradictory texts on same standards and when the treaties themselves do not contribute. In the context of the North America Free Trade Agreement, their Free Trade Commission presented an interpretative note on minimum standard of treatment, which was then included in CAFTA-DR, and that was extremely important for the Dominican Republic and its CAFTA counterparts on non-disputing party submissions in cases like TECO versus Guatemala, in which the states, in the same way they respect and do not intervene on the facts of the case, they claim that the tribunal respect the scope of fair and equitable treatment as the parties, the owners of the treaties, are the only allowed to claim what was their intentions when drafting and including such a clause. It also set the possibility for CAFTA-DR countries to present a joint interpretation on the context of its investment chapter, which, as expressly provided in the agreement, will be binding on tribunals. It shows how joint interpretations are useful, not only for its specific investment agreement, but also how it can be referenced and help to improve a different treaty. I would like to highlight the importance of what we do within investment agreements because of its implication on investment arbitration. On the same sense, what happens on investment arbitration because of its visibility may affect what happens on international arbitration in general and commercial arbitration in particular, as the public impact of what we do is undoubtedly not circumscribed to investment law. In its World Investment Reform from 2015, Chapter 4, Reforming the International Investment Regime, UNCTAD, when referring to the evolution of the international investment agreements, established the first stage from 1950 to 1964, called the era of infancy. From 1965 to 1989, the era of dichotomy. From 1990 to 2007, the era of proliferation. And from 2008 until today, the era of reorientation, characterized for the shift from BITs to regional international investment agreements, decline in annual international investment agreements, exit and revision. it talks about 6 decades of lessons learned. Now, the face of the reform is unveiled, which promotes the modernization of the existing stock of all generation treaties, as they perpetuate inconsistencies, with options from jointly interpreting treaty provisions to replacing outdated treaties, terminating all treaties, abandoning unratified agreements, amending treaty provisions, consolidating the international investment agreement network, and engaging multilaterally. But the reform of the regime is not the only option in place. We are witnessing the many countries considering not to include ISDS mechanism in future treaties, fulfilling to commitments already included in treaties such as CAFTA-DR for the establishment of an appellate body, towards standardized interpretations of the agreements, or the promotion of permanent investment courts in order to provide certainty and uniformity to the interpretations and decisions of investment tribunals. There is also third-party funding. And transparency is another issue recently evolved in investment arbitration and commercial arbitration, with institutions such as ICC making available to the public information concerning the arbitrator's appointment and taking considerable measures in cases of delay. Many institutional arbitration rules have been reformed, including ICC itself and the current work of ICSID. As I previously stated, what happens in investment arbitration, because of its visibility, has a direct impact on commercial arbitration. We don't need investment, we do need protection, but the system has shown an undesirable imbalance, which reverts not only against the state, but also against the investor through uncertainty and unpredictability. Inefficient content of treaty is against the objective of protection of the investment and the importance that the states preserves its regulatory autonomy for public health, environmental purposes. Besides the reform of all dated agreements, treaty models should follow an impact analysis that allows to validate the possible investment coming out of the signing of a future agreement, its impact on the economy and the sectors that will benefit. We do need more conclusive to sustainable development through safeguarding the right to regulate for pursuing sustainable development objectives while maintaining protection, reforming investment dispute settlement, promoting and facilitating investment, ensuring responsible investment, and enhancing systemic consistency. Another important issue is prevention, and prevention characterizes in many ways, not only through the development of ADR methods, but also through the negotiation of good treaties and a constant capacity building in order for our representatives to understand the scope of our international commitments under investment agreements and the implications of investment arbitration and the objective basis that should lead states' decisions. As sovereign, we have the capacities to provoke these changes within the treaties and the different initiatives. Through reform, the states are able to influence the agreement, tribunal decisions, and therefore the regime in its entirety. Hopefully, our approach is systematic, critical, and consistent. Many reforms are taking place as we continue engaging in investment and commercial arbitration. The economic international legal order is certainly changing, and with it, the system of international arbitration and the ISDS system. I firmly believe that the reforms being proposed and taking place will in many ways determine the future of the mechanism contemplated in many of the international investment agreements of the Dominican Republic and India, and that has brought us before many investment tribunals. Thank you very much.
Thank you, Ms. Leidylin. May I now invite the Honorable Chief Justice of New South Wales, Mr. Thomas Frederick. Huge round of applause, please.
Good morning. I was so pleased to be asked to deliver an address at this conference in celebration of the 68th Constitution Day. Can I thank the organisers for the kind invitation to what I'm sure will be an engaging and informative day. I intend to focus this morning on the theme of the Constitution, celebrating the 68th Constitution Day, and in particular on the role of constitutional law in the realm of privacy law, as I know the Supreme Court of India has recently delivered a landmark judgment declaring that the right to privacy is constitutionally guaranteed by Article 21 of the Constitution. Now, I don't intend to speak in any depth about that case, as I'm obviously ill-qualified to comment on Indian law, and I do try not to make a fool of myself all the time. Instead, I propose to offer a comparative perspective on the topic of privacy by briefly exploring the way in which the right to privacy has been dealt with in Australian law. You are perhaps wondering why an Australian judge is proposing to address an Indian conference of Indian lawyers on Australian law. You are obviously, and quite rightly, attending this conference to learn more about Indian legal principles. So at the outset, I want to outline the importance, in my view, of the ongoing study by Australian and Indian legal professionals of each other's laws, traditions and perspectives as we look to the development of our respective laws. In 1996, the Honourable Justice Michael Kirby, a former Justice of the High Court of Australia and President of the Court of Appeal of New South Wales, the court on which I preside, addressed the Indo-Australian Public Policy Conference. His Honour commented that the neglect by Indian and Australian lawyers of each other's was, and I quote, as tragic as it is puzzling. The fact is that whilst there are obvious differences between India and Australia, socio-economic, cultural and historical, there is a convergence of common interest in areas such as education, regional security, energy and resources, and international trade. In addition to this, we're both common law countries, federations, we live by the rule of law, we are governed democratically, we have parliamentary constitutions, and in our different ways, we protect fundamental human rights and basic freedoms. In growing recognition of those similarities over the 21 years since His Honour's remarks, many things have changed for the better in Indian-Australian legal dialogue. In the judicial sphere, Justices of the High Court and Supreme Court of India have met every few years over the last decades in either Delhi or Canberra to discuss legal issues of interest for both courts. At the Annual Law Asia Conference, which I've attended 5 times during my time at the court, lawyers from India, Australia and other countries in the region come together to discuss topics of mutual interest. Perhaps most significantly, in 2016, a book was published offering a comparative overview of the law and legal practice in Australia and India, with each chapter co-authored by eminent legal scholars from both countries. It canvasses areas such as diverse as capital markets and securities, litigation and civil procedure, environmental law and public health law. So it is in the spirit of growing mutual understanding that I propose to address you brief this morning on the regulation of privacy law in Australia. Now, privacy, I think, can be divided into different categories: informational, communicative, and the more traditional forms, bodily and territorial. It is the former of those, privacy as to personal information and communications, which I will be focusing on. Firstly, basic question is, what is the right to privacy? As early as 1890, it was famously described by Warren and Brandis, citing Judge Cooley, as the right to be let alone. With astounding perspicacity, they commented on the effects of modern technology, lamenting that instantaneous photographs and newspaper enterprise have invaded the sacred precincts of private and domestic life. I wonder if they could have imagined the extent to which subsequent generations would use Facebook and Insta stories to broadcast their every meal, sometimes every move, to hundreds of thousands of virtual followers. It's frightening of a person of my age, I can assure you. As we've all seen, in the 127 years since that article was published, new techniques have challenged our concepts of personal privacy in ways that they could not have imagined. Organisations now have the ability not only to collect, store and use personal information, but to track the physical location of individuals, keep their activities under surveillance, use information they post on social media, intercept emails and messages, and to aggregate data from a wide variety of sources that ultimately paints a complete picture of one's life. Naturally, our individual understandings of privacy and the legitimacy of these practices differs according to our values and cultural backgrounds. This may mean that the rationales for privacy protection or its legal manifestation differ across different countries. At a high level of generality, however, both India and Australia are parties to the Universal Declaration of Human Rights and the ICCPR, which recognise that no one should be subjected to arbitrary interference with his or her privacy and that everyone has the right to protection of the law against such interference. In terms of the accepted rationale in Australia, the Australian Law Reform Commission has stated that privacy is fundamental to human dignity and is a necessary component of freedom of association, movement and expression. We see a similar understanding in the Supreme Court of India's recent judgment, in which plurality reasons declared that privacy of the individual is an essential aspect of human dignity in turn being a constitutionally protected interest that the court considered inseparably intertwined with the concept of human freedom. Indeed, our ability to control information about ourselves and maintain a zone that is free from scrutiny by others enhances freedom by allowing individuals to protect themselves from retribution for their personal behaviours and needs. The protection of privacy operates against abuses of power in an era where information is integral to the effective exercise of power. In terms of its relationship with freedom of expression, Professor Barrett has observed that privacy is essential to freedom of speech, giving individuals a space within which to develop their identity, and I quote, free from observation and interference by Big Brother or even by a liberal democratic state, essential to enable us to read, contemplate and formulate thoughts. In one sense, we can see that privacy is a necessary aspect of maintaining freedom of speech and, by extension, of course, democracies. By the same token, the legitimate expectations we all have of a right to privacy is not, of course, absolute. There are matters of public interest that necessarily come into play, including freedom of speech itself. As Justice Chandra noted in the August judgment, the constitutional right is not absolute and may have to accommodate legitimate state aims, but those aims must be achieved in a manner which is lawful and proportionate. While our modern technology can significantly improve efficiencies in the conduct of government and businesses, it also represents one of modern society's weakest links in privacy protection. Data breaches, such as the infamous Ashley Madison website hack, can make public the intimate details of individuals' lives with potentially devastating consequences. These are challenges that also face government. An Australian government department that has recently faced scrutiny by the Information Commission for an accidental breach of the private details of over 9,000 asylum seekers. It was a scandal. It had a very good outset for the 9,000 asylum seekers. The Commonwealth Government was so embarrassed they automatically gave them admission to permanent residence in Australia, which many of them wouldn't have got enough in any event. So it was a story which had a happy ending. Now, no doubt those concerns face Indian government departments also, although the sheer volume of citizens and therefore data makes it even more challenging, I would have thought, in this country. I believe the issues of data and other security and cyber security will be discussed at the next session. Finally, there is also the competing public interest in national security, which has been a particular government concern for the last decade in our country due to the threat of terrorism. In Australia, legislation came into effect earlier this year amid some public concern, giving effect to a national metadata retention scheme. The scheme requires carriage service providers to retain information, commonly known as metadata, about all communications carried by them, though not the actual content of those communications. And that's a division that I think will cause difficulties in the future. Now, the data is obviously extremely important for law enforcement in the digital age. As you all know, French law enforcement utilised metadata to locate the department occupied by the perpetrators of the 2015 Paris attacks. Australian research has shown a greater public willingness to forgo personal privacy for the sake of national security, although you should, I think, from time to time be careful of what you wish for. Nevertheless, it is at least clear from the European jurisprudence on data retention law in the Digital Rights Ireland and Tele2 decisions that a legitimate state aim of combating serious crime does not necessarily validate general and indiscriminate retention. The difficult balance between the competing interests is the task that faces courts in jurisdiction where privacy is constitutionally protected, when even defining privacy is no easy feat. However, this does not mean the task should be avoided. This will be to succumb to what Lord Reid once famously described as the perennial fallacy that because something cannot be cut and dried or lightly weighed or measured, therefore it does not exist. But the question remains, how is it to be legally protected? Constitutionally, legislatively, by the common law, or by some mixture of them all? It is at this point I'll turn very briefly to the manner in which privacy rights are currently protected in Australia. In terms of constitutionality, as I've mentioned, the Australian Constitution does not contain any enumerated fundamental rights like Part 3, and the right to privacy is therefore not entrenched as in India. However, Australia's participation in international forums recognising the right to privacy has spurred on legislative action to protect this right. The Privacy Act, a federal act, is Australia's key information privacy law. It is in the form of what might be described as principle-based legislation. What this means is rather than traditional detailed and prescriptive regulation, it uses high-level, broadly stated rules or principles. Those principles, and there are 12 of them, 13 of them, known as the APPs, regulate the collection, use, disclosure and handling of personal information. The third APP, for example, provides that an agency should not collect personal information unless it is reasonably necessary for or directly related to one of its functions or activities. The purpose is to shift the regulatory focus from the process or action that must be taken to the outcomes that are sought, allowing management the freedom to find the most efficient way of achieving the required outcome. It also addresses the nebulous nature of regulating privacy by providing greater flexibility and future-proof legislation to meet the challenges of technology. There are also various pieces of state and territory legislation which apply to state and territory government agencies in terms similar to the Privacy Act and other state laws restricting surveillance through the use of listing optical data and tracking surveillance devices. The Australian states and territories have general jurisdiction over criminal law, and this too has been deployed to protect privacy in some jurisdictions. For example, there exist offences relating to photography being used for indecent purposes or indecent filming without consent. Finally, in New South Wales this year, new criminal sanctions were introduced to combat the issue of unauthorised sharing of images, which provides for up to 3 years imprisonment for offences of distributing an intimate image of a person without consent. One area where I think the common law has failed, in Australia at least, to keep pace with international developments is in developing causes of action for individuals whose information is released without their authorisation or who suffer attacks on their privacy. Traditionally, the common law has not recognised a cause of action for the invasion of personal privacy. Now, in countries with constitutional rights to privacy, yours now being one, the common law has been driven to keep pace with developments in technology. Now, in the United Kingdom, for example, while the courts do not recognise a tort of invasion of privacy per se, the equitable action for breach of confidence has been used, some might say with respect to their lordships manipulated, to address the misuse of private information since the case of Campbell and MGM, probably aided by the human rights legislation in that jurisdiction. The law in New Zealand has developed in the context of its human rights framework and has seen the creation of privacy tort with protecting extending to breaches of privacy that involve publishing private and personal information and for intrusion upon seclusion. In 2001, the High Court of Australia left open the possibility of the future development of a cause of action for invasion of privacy, but in the 16 years that's followed, it's still been left open and nothing's further been done. Two lower courts recognised a tort of invasion of privacy, both of them with respect without much resort to principle, and both cases settled before appeals were heard, so no superior court has ever considered the issue since 2001. The future development of the common law thus remains uncertain, and any change would obviously require litigants with the resources and determination both to initiate proceedings and take those proceedings through the appellate process. One eminent commentator has humorously, I think, described the Australian court's approach to the issue as cautious groping. That's Professor Fleming in the latest edition of his work. Whilst in Douglas and Hello Limited in the United Kingdom, Lord Justice Sedley attributed the reluctance to, and I quote, the common law's perennial need for the best of reasons, that of legal certainty, to appear not to be doing anything for the first time. Because of this reluctance, there has been numerous law reform inquiries calling for the introduction of a statutory cause of action, but there has been no action at the federal level. From my limited understanding, Indian tort law is also developing a common law cause of action, with the Supreme Court in the case of Rajapal articulating that privacy law has a founding in tort law and may give rise to an action for damages against private persons. It'll be interesting for us in Australia to see the manner in which this cause of action might develop in the future in India. It may well provide some guidance to Australian courts continuing to grapple with whether the common law should develop to recognise the cause of action of this nature or whether it should be left to legislative action. On that note, I come to the end of, you're probably pleased, of my brief foray to Australian privacy law. I hope, however, it will be of some assistance as you consider the recent Supreme Court judges and the issues that it's brought to the fore. For myself, I'm firmly committed to the usefulness of having a comparative perspective when dealing with novel legal challenges. Indeed, there are so many similarities between our legal systems that it would be a tragic loss of opportunity if we did not. I look forward to reading and learning from the forthcoming Supreme Court judgments on the issue, and I can again thank the Bar Association for the invitation to speak. I hope you all enjoy the conference. I know I will. Thank you.